need an attorney, an accountant, and an insurance broker. You just do. If you want to make a feature or a short outside of the academic world, you really need all three. So, and sometimes even inside of the academic world. So, without further ado, here's Earl.
Thank you. In terms of insurance, I've been doing this probably about 30 years now. I started out in Manhattan insuring, small commercial photographers, and then they've grown into doing commercial production, representation agencies, ad agencies, and a little bit of independent filmmakers, not too much, because most of the time you don't need that much insurance other than general liability to get locations, meet their requirements, some insurance for your cameras and film and photo equipment, and then on occasion errors and omissions or professional liability to ensure your production against claims for things such as copyright infringement, misallocation of ideas, and things of that nature. And that's basically what I do. So from my point of view, if you have any questions, I'd be happy to answer them and speak to the attorney on if something goes wrong, you get sued, the attorney gets involved, then we get involved with the insurance company. And fortunately, over the years, I really haven't had many lawsuits, thank goodness. And those that we did have were settled for, nominal payments, and it wasn't anything drawn out and too expensive.
Great. So, are we going to do a moderated series of questions first, and then?
We can. I mean, I can moderate them.
Okay, great.
Basically, for the camera. Basically, a lot of independent filmmakers may not actually get a lawyer involved, and my understanding, and this is something Mark always told me, is then you will have problems, and once you get ready to sell your film, and I know a filmmaker who's going through this now, he got all these great names and all this great press, and now he can't sell a film because he didn't get any contracts from anybody.
How does that happen?
Not doing this before, and not really doing his due diligence, and not speaking to somebody. So I sent him to Mark, and Mark just kind of said, really? But can you go over the process of what they need to do in order to make the film a contract? So they have to have in place or cast through that kind of thing? Is that something?
So, I personally, when I decided to start my own law firm, I actually have a long story about how I ended up as an attorney. I was a filmmaker first, and the people who have known me for 20 plus years here know that, because I actually had a film here a long time ago. I think 23 or 24 years ago. And I actually became an attorney because of my experience in film. So, and that was having done things correctly and still finding major legal issues. I went to law school at night while working in the entertainment industry by day. And I went to law school at night because when it came time to sell our film, we were selling it piecemeal overseas, and we didn't pre-sell the film, we post-sold the film. But we had a sales agent, and the sales agent, before we had chosen our sales agent, a crooked sales agent had sold the Southeast Asian rights to our film to some guy in Thailand, who, for whatever reason, this crooked sales agent, and I will not name his name, because of defamation, even though truth is an absolute defense, I don't want to get sued anyhow. But the sales agent had given publicity materials and just used a 2-page AFMA agreement with the AFM. My cell phone number was on those publicity materials. And on New Year's Eve, I think around 2001, 2002, I got a call from Thailand. Danny from Thailand, where are my materials? Where are my deliverables? I'm like, I have no idea who you are or what are you talking about. It's like, I paid $15,000 for the Southeast Asian rights to your film. I'm like, wow, that was cheap. Because we had been piecemealing it. And this was doing things correctly. So one of the things that I would say is we went to too big a law firm. One of the things I would say is just because somebody's a lawyer doesn't mean they understand the industry. You want domain expertise of some level. And nobody's going to say, you don't get a certificate for entertainment law. I imagine you don't get a certificate for entertainment or production insurance, because there are subsets. It's just a term. There is no entertainment law. So when I started up my own firm, I was not going to be a filmmaker lawyer, no offense, but it's just not, it would not sustain a law practice. So I would say that you have a set amount of money, you have a set amount of resources, and then you find somebody who can demonstrate to you that they know what you're talking about. There's a really good book, I can't remember, it's something along the lines of like the filmmaking lawyer in your pocket, or something like that. You know what I'm talking about, right?
Yeah.
It's a really pretty good book. But again, it's a starter. You need to find somebody early on who will kind of have at least a general understanding of all the obstacles that stand in your way. One of the things that I feel much more comfortable saying that I think Mark would, and I actually think that I'm just as conservative as Mark about a lot of things. You will get a lot of saber rattling from bigger deal people who are going to demand money and may be entitled to getting money from you. But if you don't have money, they may or may not come after you, but you're not worth much to them if you can't actually deliver money. They're looking for a settlement. I think having an understanding that you don't download, let's say, images from Google Images and then post them up onto a website, yes, you're committing copyright infringement, and yes, there's no fair use there, and they can make a demand. This isn't a cease and desist. This is an actual demand letter, and generally it starts at $7,000. And these are generally the questions I get. They get contacted by a company, not a lawyer, a company that all they do is scour the internet looking for infringement. And then there's generally a settlement.
I've had clients get caught up in that trap.
Yeah, and generally the settlement is, a few $100s, maybe to a couple of $1,000s. To a small independent filmmaker, that's really terrifying. But the fact is that copyright infringement, if there's copyright and you're using somebody else's copyrighted material, don't do it. If they actually get it protected in registration from the U.S. Copyright Office, they now can get what are known as statutory damages, which means they can get, automatic. They don't need to prove that you intended to do this, that you meant any harm. It doesn't matter if you pulled it after you've committed statutorily, you've committed copyright infringement. It's not a crime, generally, but it is a liability, and then of course you get an attorney who asks for proof and asks the accuser, please show me how this isn't fair use, and so forth, and that's when you're negotiating a settlement. I don't want you to get there. So yes, if you've already done that, pull it now, and hopefully you don't get caught. And it's not legal advice, but the reality is that when you commit statutorily, you commit copyright infringement. Yes, people can come after you, and yes, they want to get some money. They don't expect to get a huge amount, because at a certain point, people declare bankruptcy, and then they don't get anything. So start out with an attorney, with an accountant, with insurance coverage. I've heard a lot about insurance coverage, and I know you've had very few lawsuits, but one of the lawsuits that I've heard repeatedly is not getting coverage for everything. Meaning, okay, you decide we're starting production, X date, but you didn't get coverage for the run through or for the location scout or whatever it may be days before, and somebody gets hurt,
Right.
or something falls through, and you weren't covered for those dates. Boy, that's a really bad thing to happen to you, because it was just not thinking ahead. From my perspective, you cannot think as a guerrilla filmmaker, no matter how low the budget is. Everything does need to be planned out on a certain level before you even begin to shoot.
And I would add, you start with the attorney and the accountant, because that makes my job a lot easier, and it will also give you the lowest premium cost as well, because all the matters have been taken care of by the attorney and the accountant, so the insurance company understands precisely what's going on. They realize you have all the releases and all the other documentation necessary for your project, and that makes the approval a lot quicker and the premium a lot less expensive. So that's where I would start. Attorney, accountant, and then the insurance once everything is set, and then you're good to go.
Now, I did want to approach the contracts question, because you're probably not going to be able to generally hire Mark Jacobson, and you're not going to be able to hire me. But there are some recent law school grads who want to make a name for themselves, and so they will have a bundle. First of all, I don't know necessarily that you're getting a great attorney, but at least you're getting an attorney. The more you educate yourself about how the law intersects with entertainment, the better you are. I remember way back when for my first feature, it was a 35 millimeter feature, and I was interviewing different attorneys, and every attorney wanted to read the script because they were going to offer a discount based on their judgment of the quality of my script. And I'm like, because they figured they could take a percentage and they could leverage a percentage. And I was waiting for the attorney who just said, I don't care how good it is, I will serve you because that's the work that I do. You're paying me. To me, this idea that an attorney should also judge the quality of your script has no bearing. The attorney should be judging the potential liability of your production.
Exactly.
In coordination with insurance. But in general, if you're going to get a young, hungry attorney who may ask to see the script or not, you're probably going to go with them only because of the cost. But there are certain things that should be thrown into that. From my perspective, you should have like a base package that spells out everything that's inclusive. You should have a very specific retainer agreement with that attorney, so you know what you're paying for. There should be contracts. If you're doing Screen Actors Guild, they've got their base contracts. The reality is that on real sets, indie sets, not studio sets, okay, so after getting an attorney, an accountant, and an insurance broker, there is another option that may make life easier for you. If you've never done this before, from my perspective, the first hire should not even be an attorney, not an accountant, not an insurance broker. It should be a seasoned indie line producer, because that will create a shortcut to meeting people who know what they're doing when you're struggling to figure things out. And that might include a relatively new lawyer who is still getting their feet wet, but can guide you enough to, because honestly, a seasoned UPM or a line producer is going to know a lot of the contracts that are expected with crew and cast anyhow. That's why I can't believe this happened.
Oh, I know.
Because it's the attorney that will deal with the bigger names. But when you're dealing with the general, low-level office management, the line producer should be able to handle the deal memos.
I'm sure he didn't have a line producer. His surgeon gave him $72,000 and said, make a film. It's a horror. He said, horror films sell. We can sell a horror film. He blasted everybody on Facebook, but who knows anyone?
Oh, God.
And basically people who even said were shooting on set.
Oh.
And yeah.
Was this FICOR?
Not everyone.
Okay.
Yeah.
Because if you don't know, there's something called FICOR. I had never heard of FICOR until a couple of years ago. But yes, I think so for my perspective, in aligning with an insurance broker, one thing that most attorneys who don't work in entertainment don't understand, and is very important, is the concept of chain of title. Have you heard of chain of title? The idea is that anything that you use that doesn't inherently belong to you, you can track who it belongs to and why you have permission to use it or own it or have it in your piece, whether it's music, whether it's a video clip, whether it's actual and artistic work of any sort. And so, and we were discussing this a little bit before, I went through Act 1 clearance to get risk assessment on my script. Sometimes you go to an attorney and get an attorney opinion letter. Here's where you're possibly encountering distribution errors and omissions issues, because there's errors and omissions insurance. You can't get it unless you really get this, a really valid understanding of what the risks are in using previously owned work. But there isn't a set document for chain of title. It's just knowing to ask for it, and most attorneys outside of the entertainment field don't remember to ask for that. I would say out of all those things, and I know we're probably going to have a lot of conversation about intellectual property. Intellectual property matters, and music law is the most labyrinthine type of law there is. And when you're dealing with music, you really can't screw that up. You really can't. So don't even think about using music that doesn't belong to you without getting the rights first. Just one last story that I'd like to tell about my production that showed here. What was released in distribution was different than what's showed here because we used the song Beyond the Sea by Bobby Darin. But we didn't just use it, we actually wrote to the musicians, we wrote to the law firm that represented the songwriters, and we wrote to Warner Chappell, and we got festival rights for free. So, yeah, for free. It's great. So, we went to every festival. We went to great festivals. We were here. We won, I think, best first feature maybe. I still got my big trophy on my mantle. It looks so much like an Oscar. And then it came time for theatrical distribution. And the two attorneys, I think they were in Nashville, who represented the songwriters, were fighting over the Bobby Darin estate. And they weren't getting back to us. And finally, this was, like I said, this is a 35 millimeter film. We needed to get an answer. So finally, we paid for worldwide perpetual rights for use in trailers and in film for this one song that had been submitted to me years before that I also liked and worked pretty well. It actually worked really nicely. But it was an original song by a local swing musician. Ron Sunshine in Full Swing, I think was the name of the band, and they were great, and it sounded great. It was a great approximation, but if I hadn't done that, I would have been in a world of trouble. So,
Yeah, that all of you discussed doesn't really enter into the insurance aspect of it. It's all very interesting because I'm learning what goes on even before I get involved. But the insurance is when a claim or a demand letter comes in, and now all of a sudden you say, oh my gosh, what is going on here? And the way I look at for the independent filmmakers is you're purchasing defense insurance when you buy errors and omissions. Because if you do get sued, even if it's frivolous and has no merit, it could cost you $100,000 just to defend the action before you even get to court or before it even gets dismissed. So for a couple of $1,000s, you can sleep well knowing that if something does happen, no matter how frivolous it might be, at least I know I can pay the attorneys and I'll be able to sleep at night. I don't know if there's any specific questions on errors and omissions.
Or, is that something that you pay yearly? And for how long do you pay it?
Typically for an independent film, it's usually a 3-year policy. And even if you're sued 5 years down the road, it's still during that period, it's an occurrence-based policy, so it's when the actual filming was done, even though you might be sued 4 or 5 years later. I don't know what the statute of limitations is. It 7 years?
on copyright, 6 years, I
6
believe.
years.
But you have to be very careful with, I don't know what it would be in terms of in this situation, because I know that, for instance, there's a 6-year term. So there are different statutes of limitations, and I can't remember the different statutes of limitations at this point. But I do know that one of the problems that has occurred when it comes to copyright is that there are renewals of tolling the statute. I will give an example that ultimately got thrown out, but it was 50 years, and I couldn't believe, and it was practically 50 years, and I don't know if you've ever paid attention to this Led Zeppelin Spirit case. I mean, that's 50 years later, and it was over Stairway to Heaven. And by the way, I teach this in my media law and entertainment law class. If you play them side by side, those chord progressions are identical. And you need, for copyright infringement, you need access and opportunity. And people are mostly like, come on, really? Led Zeppelin stole, Taurus? Well, the reality is that they opened for Spirit in the late 60s. So they had access and opportunity. But my question, and they ultimately lost. There's a 57-page opinion a few years ago. They ultimately lost, but I could not understand how you could possibly bring a copyright case, 50 years later. The reason was because it was remastered and because it was on different formats, and so I guess they sought out and got renewal of the copyright. But yeah.
I have a question going back to your shared title thing and sort of about that 50-year later thing. What about stuff like in public domain? Like, how do you approach that with shared title?
You would demonstrate that it is in the public domain.
How do you do that?
Okay, so when you're talking about specifically copyright, am I correct?
Yeah.
Okay.
Like a literary work, for example.
What's that?
Like a literary work from 100
Oh,
years ago.
that's an easy one because there's a wonderful thing that I always tell my students to pay attention to. January 1st is not only New Year's Day, but Duke University always has Public Domain Day on January 1st, and that's when they celebrate the arrival of works in the public domain. Now, Public Domain Day in 2024 is going to be very exciting. Does anybody know what happens that day?
Mickey Mouse.
Mickey Mouse. This has been, awaited for so long. The thing is, it's not going to be that exciting because, hold on, I bet you're going to ask me about Pooh.
It's going to be the original Steamboat Willie version.
Wow.
Yes, and that's true, but on top of that, Disney finally anticipated that you're going to be dealing with something else. So what do you see at the beginning of every Disney picture? You see Steamboat Willie, because it's now protected by trademark. So you have to be very careful. So a lot of people may remember you had Pooh, was it Blood and Honey?
Yeah.
And there, the original work was a literary work that was bought by Disney. They made sure that when it fell into the public domain as a literary work, they didn't use any of the characteristics of the Disney version of Winnie the Pooh. The evolution of Mickey Mouse, I think, would be the same thing. But if you want to, if you want to do, Mickey or Steamboat Willie, Blood and Cheese, have at it. I think you will still be getting cease and desist letters, if not outright. And I'm sure everybody is going to be testing this just to see what happens. This is, there's a big spotlight on this, but this was an issue. One of the things that I found fascinating, and I haven't heard anything in the world of litigation. Rhapsody in Blue entered the public domain, but that's also. It's my understanding, it's also kind of the trademark audio for United Airlines. So I'd be curious to see if another airline company used it in a travel service. I'll digress. I represented a travel-related services company, and I applied for a trademark for them, and a year into it, there was opposition to their mark because it had the word advantage in it. American Airlines, and now this company had been existing for 20 years. I did not advise them that American Airlines would swoop in after a year and challenge the mark. But they challenged the mark. They weren't coming after them for money. They just didn't want the monopoly. And if you think about intellectual property, the concept of intellectual property in America really, in many ways, dates back to the U.S. Constitution. You have a fundamental conflict. On the one hand, we celebrate in America, we celebrate the First Amendment and artistic freedom. And even though it doesn't say freedom of expression, it has been judged to be protective of artistic speech especially. On the other hand, there is a portion of the U.S. Constitution that deals with patents and copyrights or creative works. That doesn't include trademark, and trademarks are generally not considered creative works. So you have this dichotomy. In this case, when it comes to trademark attorneys who are litigators aggressively go after trademark infringement a lot more than copyright infringement. And as a result, I had suggested to them, because they were just opposing the mark, they weren't coming after them, that they continue to use it, but they would not get the monopoly power, the exclusive ownership of the use of this mark. And so when you're dealing with intellectual property, you talk about chain of title, public domain, very easy to ascertain. Look at the Duke site, and generally it will tell you when a literary or artistic work is up for public domain. There are other situations where works fall into the public domain, such as NASA images. Any federal government, and there have been issues regarding state governments and municipal governments, that any federal government created work is de facto in the public domain. My favorite all-time case, which also relates to I'm sure some questions about AI, is what is known as the monkey selfie case, where a photographer went to Indonesia and lived among the macaque monkeys, I think Borneo, and brought a whole bunch of cameras, and he fell asleep, and when he woke up, one of the monkeys had taken tons of pictures, and some of these selfies were really, really good. And he posted them online and said, look what Naruto, took the picture of, and it went viral. He then was really upset to find out that Wikimedia had republished it, and he sent a cease and desist letter, and I think a demand letter, and they said, no, this is in the public domain. And they went, and this was a British photographer. So then, on the one hand, if he hadn't told everybody the monkeys had taken the picture, it probably wouldn't have gone viral. But because he told everybody the monkey, he curated the images. There were hundreds of images. I'm personally in favor of a copyright protection for curation. But the U.S. Copyright Office did not agree with him and declared, added to their compendium, that artistic works that are created by non-humans, and this is where artificial intelligence comes into play, are not creative works, or they're not originally authored works, and are therefore not protected by copyright. Well, on the other hand, you can have a compilation of non-protected works in a certain order, set up in a certain way, and then you can be protected by copyright for it. So for instance, a recipe book. The recipes cannot be protected by copyright, but the order of the recipes, the photographs that accompany the recipes, so on and so forth, can be protected by copyright. So he creates a book of the monkey selfies, and he gets sued. He gets sued by PETA, acting on behalf as a friend of Naruto the monkey. It goes all the way to the Ninth Circuit, and one of the difficulties was, does Naruto have the ability to agree to a contract? And was it actually Naruto who took the actual picture? Ultimately, they settled. I don't believe they necessarily had a finding, but animal rights lawyers are actually fighting for the creative rights of animals. But that also filters down to AI, because if it's non-human, now understand, this is just the interpretation of the US Copyright Office, but there have already been lawsuits related to Marvel. For instance, pirated software related to the creation of Thanos and a number of other Disney and Marvel characters. It turns out that that software was pirated by a Chinese software company and then sold back, and ultimately sold back to Disney. And the original creators of the software sued Disney for copyright infringement because they would not have, and for billions, because they would not have been able to create Thanos without the software. And most of the case was thrown out because they're arguing for copyright infringement when it was the software that actually created the likeness of Thanos with human input. But the one aspect that was not thrown out was the fact that the code itself was still considered protected by copyright. So understand that the minute you create something, you fix an original work in a tangible medium, it is protected by copyright. Until you apply and receive registration from the US Copyright Office, you do not have the ability to sue over that. But once you do, you have an exclusive right to protect that, except when it comes to music. Music, there are blanket licenses, and I'm not going to get into that do not pertain to film, because those are sync rights, SYNC. Those are, a music creator does not have to grant rights to a filmmaker under any circumstance for use of music. But anybody can use, under certain circumstances, music for performance or for printing as a recorded work, as a cover. The music creator doesn't have any say over that. I know that was really long-winded. I'm sorry. Yes.
So I guess just in the context of documentary filmmaking, what I'm trying to understand is usage with, like, if somebody posts a TikTok, for example, and you're trying to, in a journalistic sense, use that as an example of something. Like, at what point are you allowed to use something? What point are you not? Like that, it's like very gray to me. So
this is where I'm gonna channel my inner Mark Jacobson, because it always comes up into play, and this is where we talk about fair use, and fair use is no fun. There is a really great guide to, I think it's called Best Practices. It comes out of Pittsburgh. Best Practices for Fair Use. Fair use best practices for documentary filmmakers, and it's a very good guide. But fair use is all over the place. And recent U.S. Supreme Court decisions have indicated that that the current U.S. Supreme Court is not necessarily fans of fair use. That being said, there are 4 factors of fair use. This is where you would talk to an attorney, and the attorney is going to say, I cannot protect you absolutely. I do believe this is fair use, especially in a journalistic context, especially in an educational context, so on and so forth. But it depends on how much of the piece you're going to use. Generally, it would be under, just the amount necessary to convey what is necessary to convey. which shouldn't be the entirety of the piece unless you need the entirety of the piece to convey whatever emotional or informational element. But even there have been successful fair use cases, such as the Broadway show and this is an interesting case, Hand to God or Hand of God. Anybody know this Broadway show? I think it was called Hand to God, and it involved an autistic boy who had like a sock puppet on his hand, and he communicated through that. And this case is really fascinating because it was the sock puppet did the entire Who's on First routine. And Abbott and Costello's heirs sued over use of the Who's on First routine. It's the entirety, and generally you don't ever want to use the entirety because, and ultimately they lost, but there were a number of reasons they lost. For one thing, did they actually own it? Because it was used in vaudeville, but it was also used in movies. It was used on television, but when it's used multiple times, generally there's either a license or an outright assignment of copyright. And I think that wasn't clear. But the other side of this was the original judge said this is flat out fair use. You needed the entire, I thought it was a bogus argument, but the judge said you needed the entire routine to truly convey, and it was transformative. You'll hear this word a lot. Is it transformative? Well, I don't think it is. It's not.
What do you mean by that?
It's a great question. Because that's been applied to various fair use factors. There is another case involving the sculptor Jeff Koons, and he created a sculpture of a couple sitting on a park bench with a bunch of puppies, and it really looked so much like a photograph that the photographer sued and won. And the holding was it wasn't transformative enough. And I'm thinking, you took something that was two-dimensional and made it three-dimensional. That's pretty damn transformative. Again, I wish I could tell you better, but this is why I would say that it's on a case-by-case basis. When submitting it for potential errors and omissions insurance, you would point out the potential liability, but whoever is judging it as an attorney with the attorney opinion letter says, in my estimation, because this is an investigative piece, this is revelatory, it may even have a different form of meaning to render it transformative. All these aspects would be a reason that the errors and omissions insurance should be granted to this particular work.
Yeah, and take that example of using the TikTok in a documentary. What kind of cause of action do you think they would cite? Because I'm wondering, bodily injury is not covered in errors and omissions.
No, but copyright insurance.
Yeah, copyright would be.
So
what
it would
they
have to
say
be.
it's emotional distress or outrageous conduct.
Okay. So causes of action.
You need a cause of action.
Causes of action are ways people can sue other people. And so I wrote an online guide a bunch of years ago. It was like how to make. I can't even remember the title. It was something silly like how to make a movie based on real life and not get sued, or something along those lines. And it was based on a continuing legal education lecture workshop that I gave at the Nassau County Bar Association. And there's a concept known as life story rights. It's not something you apply for. It's just something that you contractually agree to. And what it really is a promise not to sue. Because there are so many different ways people choose to try to get money from other people, especially when you're successful, that it's not just copyright infringement, it may be trademark infringement, as I just mentioned before, and a lot of people still need deep pockets to protect themselves if they do get sued. So I mentioned this article I just read about Peloton as being sold on Amazon, and now it's kind of Hollywood approved, although I don't know what that means, but it referenced an episode of this sequel to Sex and the City, where somebody dies on a Peloton, and could that be trademark infringement, or could that be trademark tarnishment? This is where that dichotomy in the U.S. Constitution comes into play. On the one hand, you have the First Amendment and the celebration of artistic freedom. On the other hand, you have trademark, which is a form of intellectual property not identified in the U.S. Constitution, but still celebrating monopoly power and exclusivity. The reality is that we've had a lot of cases related to use of trademark, and in general, courts have come down in favor of artistic expression because of the First Amendment. That being said, just recently we had another one of my favorite cases that just got decided, in my opinion, wrongly by the U.S. Supreme Court, which was the case of Bad Spaniels. Has anybody heard about Jack Daniels versus Bad Spaniels? And there was a dog chew toy that was modeled after a Jack Daniels bottle, and had references to number 2 and things like that. And it was hilarious. I'm sure you've seen this in the store. Bad Spaniels lost to Jack Daniels because there isn't nearly as robust a fair use exception to trademark as there is to copyright, and you have to be very careful of copyright. So the origins. So trademark is for commercial speech. So there have been cases. There's something known as the Rogers test that involved a movie by Fellini that was called, I think, Ginger and Fred, and Ginger Rogers sued and lost. But that was Second Circuit, that was New York. It never went to the Supreme Court, and so the Rogers test has been generally applicable to New York. Meaning, if you're not misleading the audience and it's got artistic merit, you can use it. And so this applied to a recent decision. A lot of this is in video games. You had Jim Brown, who lost on the Rogers test, I believe in the Ninth Circuit, for the use of his jersey. And video games is an area, and tattoos are another area that are somewhat up in the air. But you just had Call of Duty? I think it was Call of Duty that involved the use of Hummers. And they actually had the actual Hummer logo on the Hummers. And as long as you're not putting it on the box, then really, so much of it's downloadable anyhow. But on the advertisements, don't put the trademarks on the advertisements. That would be foolish. But if you're not using the trademark to sell the product, I think generally you can have it as long as it's not truly tarnishing. Like if I didn't see this episode, but it's like, oh my God, that Peloton killed me. That would probably not belong in your script, okay? But other than that, I think you can have, as long as it really is capturing the artistic expression and not trying to be used in commerce. You had another video game case involving Lindsay Lohan, and she lost this was actually a right of publicity case and a trade. I guess it was a right of publicity case, and New York doesn't have a real right of publicity for living people. But there's this character named Lacey in Grand Theft Auto that she claimed was modeled after her, and really insulting her, and it was used on the box, name, image, and likeness. But New York doesn't actually have a right of publicity protection for living people. So she did invasion of privacy, which is even harder to prove, and she lost. But in general, if she were in a different state, or she had trademarked her name, image, and likeness, and they had used it in a very similar way, I think she could have had a legitimate claim.
Thank you.
I got two questions. The first one's for both of you. Even when you encounter filmmakers who have really done their homework and they know what they're talking about, or they think they know what they're talking about, and they get everything ready to go into production, what is the one thing from each of you that you find is most, they forget the most? What's the one thing that they may have everything, they'll have 19 out of 20 things, but what's that 20th thing they should have that most indie filmmakers, in your opinion, kind of don't know about or neglect to do?
So, now that I'm the chair of a film division, I'm not nearly as popular as I was when I was an adjunct professor. And the reason is because we have a call sheet. And we don't even do production reports. But you should be doing, most people don't know how to do production reports. Most people don't know how to do the paperwork. And the paperwork is absolutely necessary because if things go, if things go right, you're great. But you can't retroactively do the paperwork that you generally have to do. All I really care about, and I'm trying to really implement with our students, because the students don't, they just want to go out and shoot. And I think we've always had that celebration, and at a certain point we recognized, and obviously you've had some high profile, terrible things happen. I'll give you an example of something that happened in my neighborhood a couple of years ago. That, two kids wanted to create a YouTube video. So what did they do? They wanted to stage a home invasion. They didn't contact their local PD. They didn't contact their neighbors. They didn't think somebody might call the police and say, "Oh my God." These are really stupid things. So we have a checklist of really fundamental things. Like we call them special activities. People hate them because they need to clear it with us. And special activities include anything that involves any form of exercise. Running. You have running, I need to know about it. Okay? All the way to, last year I had a senior who wanted to have somebody fall off the side of a boat. Now, this was for her senior project. You remember this? No. This was for her senior project, and it was November. She had 6 weeks till graduation, and I said, "You've got to be kidding me. Are you?" I was just like, and she started to cry. I'm like, "You can't cry over this. There's no way." I wasn't yelling or anything. I was just like, "I can't believe that you would actually think." She's like, but so-and-so's a lifeguard. I'm like, "No!" And so I would say that, taking the precautions. Now, we have a policy now that if a special activity occurs off campus, we need to get a certificate of insurance. Because again, our school has insurance protection, and I can't get it into people's minds. This is to protect you. This isn't to be mean. And we don't charge our students for it. I know other schools, I believe Columbia, NYU, they charge their students for insurance every time. We don't do that. So to me, for the life of me, that somebody wouldn't take the time to have the reports, to have the checklists. There's a book called The Checklist Revolution or something like that, and it was about. I got you next. It was about surgery. Now, at one point, I was a wrongful death and medical malpractice trial attorney. Long story. I never planned to do that. But checklists are really important for everything. If you have a checklist, you're so much more likely not to screw up.
And from the thank you. And from the insurance angle, what's the one thing that people always seem to forget?
Well, it all depends, because some of the smaller independent filmmakers don't use insurance unless they're forced to, just because of budgetary reasons. So if you need a permit to do a shoot, and the town of Oyster Bay requires $1 million of general liability, you're going to have to purchase that. You should always have workers' compensation if you're paying cast and crew members, because if they do get hurt, you're personally liable for covering their medical expenses, plus facing a big fine and penalty from the New York State Workers' Compensation Board. In terms of your equipment, if it's your equipment that you own, you don't have to insure it. You can just self-insure and hope nothing happens, and usually it doesn't. It's a rarity for cameras and things to get broken. And we spoke about errors and omissions, and I find unless it's required by whoever's hiring you to do the documentary, for example, like I've had clients do them for ESPN and MSG, and they required $2 million of errors and omissions for a 3-year period. But really, it depends on what your budget is and what you're forced to purchase, and to have due diligence. And there are short-term production policies that are available that are pretty reasonable, where you can encompass all these coverages, including prop sets and wardrobe, third-party property damage, which would mean if you're doing a shoot in somebody's house out in East Hampton and it gets damaged, you have coverage to repair the marble floor that gets scratched, or a piece of furniture, expensive piece of furniture that gets damaged. So it's something that I do. I work through with the client when they approach me on what the project is and what insurance that they definitely have to have and what they can get away with, and kind of self-insure on their own.
Thank you, gents.
One thing about the insurance, one of my students was covered by insurance, and said, came to us and said, there's a potential claim. And I said, what's the claim? The bidet handle. I said, find out how much the bidet handle costs before we're going to put in a claim. $15.
Yeah.
Okay, so sometimes you get the insurance and just say, okay, let's not make a claim, because it's a $15 bidet handle. Personally, I actually have said this in my producing class. If you're gonna, even if you're way low budget, tell wherever your location is, you're gonna pay for a cleaning crew. Clean up after yourselves. It's just so. To me, it makes sense. Same thing with errors and omissions insurance. You're not going to go out and get errors and omissions insurance, but you might as well find out if you're going to ever be able to get it, if you care about distribution in any way. If you know that you can't get errors and omissions insurance, why not find out now? Talk to an attorney, or go to a Act 1 or another clearance house and find out what the likelihood of getting that errors and omissions policy is.
Yeah. I didn't mention deductibles, and that's also important. There's no deductible for general liability. There's no deductibles for workers' compensation. Pays 100% right from the first dollar. There's usually a deductible on camera equipment, usually $1,000 to $1,500. Prop sets and wardrobe about the same on that. And errors and omissions, the standard minimum deductible is $2,500. said, a simple little handle is not going to be a claim. A lost cell phone is not going to be a claim. So it's when it exceeds those thresholds. And in terms of that stunt with the person falling over a boat, was it a moving boat?
No.
Okay. If it was moving, that would be uninsurable. Or it would be very expensive, and you'd have to have a professional stunt person.
Yes.
You'd have to
You
have
should still have this professional
Right,
stunt
you'd have to have EMT there, you'd have probably have, not the
Coast
Coast
Guard,
Guard,
or-
but, you know, a local.
Harbor police or
Harbor
whatever.
police there, and that's even if.
And it's
if
November.
Yeah. So stunts are on a case-by-case basis.
Thanks, guys.
You had a question?
Since you're giving free consultations right
No, I'm not.
You came in here late, and I specifically started off by saying none of this constitutes legal advice.
And no recording.
Is it possible we're creating a show and the show is based on a business, but the business has huge marketing capabilities? Should we be trying to trademark said marketing capabilities? For example, it is a coffee shop and we have a certain drink named something. We don't want Dunkin' Donuts to go and say, wow, this show's a hit. We now serve this coffee.
Mm-hmm.
Is that something you could protect?
Okay. So, yes, you could possibly protect it in a number of ways. And I give this example because I had a real life client that I just sent to somebody else because I didn't want to deal with it. Because it was in different states, but I use this as an example of rent a lawyer, okay? Because that's not what this was, but I couldn't reveal what it actually was. First of all, intellectual property, true intellectual property generally is patent, trademark, and copyright. In addition, there's other things known as mask rights, trade secrets, which you cannot apply for a trade secret, but they very often can be protected by non-disclosure agreements. And then there are quasi-intellectual property rights, namely rights of publicity, which vary from state to state. Name, image, and likeness, you may have heard a lot about this because the NCAA just finally lost on this issue, and even area high schools, believe it or not, have name, image, and likeness, NIL rights. When it comes to processes, believe it or not, processes can be protected. Those can be protected as inventions. Those can actually, so if you've got something truly novel, you might want to talk to a patent attorney and get that protected before doing anything with that, because Amazon, I think, patented one-click or something like that. Buy it now. I think that's actually protected by patent. Now that's a short-term protection. I can't even remember what patent protection is now. I know my father has had a number of patents, and that term has been shortened considerably. Then you have trademark, and trademark also, so I'll give you an example. The most visible example is Coca-Cola. The Coca-Cola bottle is protected by trademark. Trademark can be perpetual. As long as it's used in commerce in a specific class for in perpetuity, it can be protected by trademark. We were talking about Steamboat Willie. Steamboat Willie, as long as it's used in motion pictures and whatever else it's used for in commerce, it can be protected in perpetuity. Patents are the shortest amount of time. Copyrights are, again, creative works, and there's a robust fair use. So, and by the way, with trademarks, there's the danger of something becoming what is known as genericized. So, for instance, aspirin used to be protected by trademark. Then everybody referred to aspirin, and suddenly it was generic, and it was not protected by trademark. Escalators. That's why Jeep, forced everybody to go to 4x4s or SUVs. If you watch any HGTV, for the life of me, I could not figure out what loop and lock was until I figured out, oh, it's Velcro, but you can't say Velcro, because if you say Velcro, you're diminishing the strength. Kleenex, Google has been very aggressive when it comes to trademark. So if you've got something that can be protected, and there are various tiers of, so you cannot have a generic item be ever protected unless it acquires what is known as secondary meaning. So you cannot take an apple and call it Apple and try to protect that trademark. However, you have Apple, you have Apple everything. This is an interesting situation because Apple was computers, but eventually they went to music. There was already an Apple Records. So again, and that becomes a question of confusingly similar, and again, it's in per mark per class, because classes are categories of protection. So you can have, in the same marketplace, you can have a Dove chocolate and you can have Dove soap. And unless Dove soap decides to make an edible soap, or Dove chocolate decides to make, cocoa butter, you probably won't have a conflict there. I don't know if this helps, but if you, when it comes to wanting to protect something, you want to protect it at every angle if you can.
So if I make a soda shop and my name's Kurt, so we make Kurt Cola, and the show goes crazy viral, and we see a store selling Kurt Cola at the store.
That would be a problem. So I'll give you an example.
Kurt Cola.
Let me get back to your question, because this hypothetical, which was a real situation, was my client had a business, rent a lawyer, and had a whole series of processes, and was posting on Instagram and posting on Snapchat, not Snapchat, but posting on Instagram and posting on YouTube, and her friends were saying, "Oh, you gotta make this happen. You gotta franchise this. You gotta." And she actually, I think she got a trademark on it. But then she was interviewed by CNN, and she told her whole life story, and then somebody took that story that was on CNN and turned it into a movie. And she had agents. Or she had been interviewing agents for selling her life story. This is where the whole life story rights comes into play. Now, there was a whole tangle of issues, including threats made and unfair competition because people knew people and were calling up the agents that were going to represent the person who had written this. Oh, it wasn't a movie. It was a book. It was a novelization, and so people were calling the novelist up and threatening to sue, and it became a nightmare. She should have gotten a trademark. She probably, in my opinion, before going on CNN, probably should have created a treatment of her story and submitted it to the U.S. Copyright Office, and then gone on CNN before somebody, because it was her whole life story was wrapped up in this business.
Isn't that relative though? And what I mean by that is if you change your name, maybe profession to a certain degree, locations, you can still keep the point of the story, the point of the storyline, and now they can't say it's.
You have to be careful, because copyright has also a similarity issue. It's not the same thing as confusingly similar, it's substantially similar. So, I think back to, I don't know what happened back in 1988, I think it was, but McDowell's versus McDonald's and Coming to America, where you have the trademark infringement, but they acknowledge it. If it were, but remember that was for artistic purposes, and we're dealing with the Rogers test. I think this no, I'm not sure. No, Rogers came before that. But that was for artistic purposes. But if you're basically ripping off, I don't know, what's that? Indiana Jones, and if it's like, if it's Ohio Smith and the Smile of Festamy, okay? I think even though that, believe it or not, you cannot get a trademark in a title, but you can get a trademark in a series.
Yeah.
So, and that's just, you cannot get copyright protection for a title. There's not enough original creativity, enmeshed in the title. But I would be very careful about ripping something off and just changing the names, because if it's found to be substantially similar, you're SOL.
Thank you.
Thank you.
So, talking about things in public domain, and you may have actually answered this with the whole concept of who's on first, but I've read a few times, not often, but a few times, about songs that have entered the public domain, where the song itself is in public domain, and I've seen a lot of the estates of the artists and artists and singers of the same era claim otherwise. Is this something that's actually, because in terms of filmmakers looking to use songs that are in the public domain, is this something that's actually legitimate and actionable?
Well, this is referencing, in my mind, a very interesting case, and I don't know if I'm going to get this correct now. I don't know the ultimate outcome, but I don't feel like it was just involving Happy Birthday. And I believe it was a documentary filmmaker who made all this happen, because this documentary filmmaker wanted to do a documentary on the song Happy Birthday, and it was a documentary, and I believe Warner Chappelle wanted to charge her $1,500. And so then she did a whole deep dive and found that, in fact, not only was the tune not protected, I actually can't remember, because when you're dealing with music, you're separating it into a composition and recording, and very often you could be also separating it into lyrics and the composition itself.
But that's what it was. They were claiming the recordings themselves.
So, well, the recordings would be easy to figure out, and there's a whole aspect to music law that involves the switch over in copyright to sound recordings that starts in 1972, and there have been because you used to have state copyright, there are no state copyright laws anymore. So I think, and again, I'm not dealing with this on a regular basis, but when somebody claims that something is in the public domain, they need to, again, show the chain of title, show when the registrations were. And same thing with the recording. Okay, so for instance, if a song enters the public domain, but the performance might not. So I mentioned Rhapsody in Blue. If you could record your own version of Rhapsody in Blue, it's in the public domain. But you can't use the recording that United Airlines has been using for God knows how long. Because that assuredly is still, that recording, that performance is still protected.
So the recording itself may not necessarily be a public domain, even if it's
even if the composition
has hit that edge.
Yes.
Yeah. Okay.
In fact, it probably hasn't entered the public domain.
The performance is different than the piece.
Right.
That's
No, but
what I'm
my point was like if the recording is just as old.
So it may be, but it probably isn't.
Right.
And again, we're getting back to that whole Led Zeppelin. So let's say you have the original 1924 or 1924 recording, but it's been updated. It's been remastered. It's been there are still questions about who owns the split sheet. I remember when they re-released the Beatles, Sgt. Pepper's, and I got the new vinyl, but was it George Martin's son who oversaw the remastering, and it basically became a new work. I mean, it had never been released in this way, even back in the 60s. So you have to be very careful, even if that original recording entered the public domain. I would find it hard to believe that that it was still in the public domain. I could be wrong, but I would say that if the composition has entered the public domain, create the new work.
I have a question. So let's say there is a mother who likes to post their child a lot on Facebook, TikTok, YouTube. As they grow up, child turns 18. Who owns all of that? Is it the mom who posted all of that? Is it the child who's a part of that? Well, not just Facebook. Let's say YouTube or TikTok, like the quote unquote mommy bloggers are a big thing. So like, when a child turns 18 and of age, is it mom who owns it? Is it the child who owns their identity that was of them as a child?
So it's funny you should bring this up because I teach law, and this is part of one of my hypos, one of my questions, and it's a fictionalized version of Taylor Swift. And when she turns 18. So there are various laws involving minors, but also there are questions. Okay, you've opened a can of worms here.
Yeah.
First of all, I'll give an example of a real life situation that I was dealing with when I was representing musicians who wanted to acquire beats and stems to accompany their own vocals. And I was going through all my checklists, and first of all, beats and stems are not necessarily protected by copyright. Are they suitably original enough? I think they are, but I don't think that's necessarily been established, and chord progressions generally are not protected by copyright either. I went through all this, and then I was about to go to the contract.
5 minutes.
Oh, really?
Yeah.
Oh my
Believe it or
God.
not.
I was about to go to contract, and I found out that the author of the beats and stems was a 15-year-old kid in North Carolina or Atlanta. I can't remember. And I'm like, oh, now we have to have essentially, remember the monkey trial? There's a friend of the child, the guardian, a minor does not have the capacity to enter into contract. That said, generally the creator of an original work, if right now, John, unless it's a work made for hire, he is the owner of this recording. I am not the owner. I may have other rights, but when it comes to copyrights, it's generally the person who fixes it in a tangible medium. So generally, the parent would have the copyright if the parent is recording the work. However, there may be invasion of privacy, rights of publicity, depending, those vary state to state. But even if you say, I had the approval of the minor. Unless the minor is emancipated, the minor does not have the capacity to enter into a contract for approval. And in fact, in many times, a minor can disclaim that contract once they reach majority age. This involved the band, I believe it involved the band New Edition, where they wanted to, Maurice Starr wanted to claim ownership. Oh, I can't remember the exact case, but, and it differed from Menudo, which was created for a very different purpose. But yes, that's a very complex, and when you're dealing with kids, you know, like they say, kids and animals, you have a whole bunch of new issues to deal with.
Well, we actually have to end this.
Oh, I'm so
I want to
sorry,
thank
Earl.
Earl Eaton and Michael Prywes.